Hello, ladies and gentlemen. The following is a podcast that we did on November the 28th, 2010. It's John Reed is not with us today. It's the three of us, John, Donnie, and Bob. And we are discussing land trust. And land trusts are part of a package to help us protect our assets within our company and individually. It's just one of the tools that we use to potentially protect our assets. We'll be discussing that today. Today's podcast is over an hour long. We each have different viewpoints and different ideas on how to protect our assets, individually and within our company. So it'll be interesting for you to hear our different ideas and viewpoints. As usual, you can find us on landlordsjournal.com and view our schedule. And find our podcast if you want to hear the audio only on our website and on iTunes. Thank you.
Can they go look at my bank account?
We kind of had foregone the usual intro to our show that Donnie usually does. I pulled this off of Ustream. So again, this is landlordsjournal.com podcast, and we are discussing. We are discussing land trusts and their value for asset protection and many other uses.
Easily find that out if you don't hold your property in a land trust. If you hold it in your own name,
may not know. They'll have a pretty good idea what the value of your property is and how many pieces of property you own.
If you just have it in your own name. So that's one of the values of having a land trust right there. What is a land trust?
No one's going to answer. Go ahead. You've got it pulled up, so
yeah, I have it pulled up.
Since you have that, I thought it'd be most appropriate for you to do that.
A land trust is a way to manage complex divisions of the bundle of rights that people can own in real estate, and can be used to manage something as large and complex as a multi-state REIT, or something as small as a single-family home. Corporations sometimes set up land trusts when they want to compile large tracts of land without arousing suspicion or alerting people to their plans. Which, I guess basically it's a document. I mean, I don't know. It's a trust that's recorded at the courthouse.
And it's a legal entity that would possess something.
Right.
It is. It's a division between the ownership and the rights of property. Right. It's a way to. If I own a place and my name is on it, I am the. I'm the owner, plus I carry all the liability and such for that property. But if I have it in a trust, I can control the property without having. I can convey. In a land trust, do you convey the ownership to your trust, yet you still control the property?
Well, it's not really any different than. Is it any different than? I mean, it's technically a different. It's a different instrument or a different mechanism than an LLC. But is it, for practicality purposes, is it any different than a corporation or LLC?
Yes, the main difference between an LLC and a land trust is, like I was mentioning before we were on air, is a LLC, if you have a note, like say in your name, If you have, well, wait, let me finish, please.
But I wasn't. You didn't get my. You didn't get
What
my.
is it? What is it?
I'm talking about for the purposes of Johnny's. I mean, excuse me, Donnie's description, where we're talking about ownership. It's still that thing owns a piece of property. If you transfer ownership to a trust, then different people can have an interest in the trust. It's not really a separation between rights and ownership, because the full rights and full ownership go to the trust when you transfer it, and then whoever has rights to the trust is who has ownership responsibility.
Exactly.
I'm looking
it could be a corporation. It could be an LLC.
Well, it may not be true. I'm not stating for fact.
I'm looking here at another definition. It says, the purpose of a land trust is to allow one to have the legal title to his property held by another person or trustee while retaining all the rights and privileges of property ownership.
And that's contrary to what I just said, and I don't understand that.
How's it? What do you mean? How's that contrary to what you just said? Read it again, Donnie.
The purpose of a land trust is to allow one to have the legal title to his property held by another person.
Right. So I could have. Go ahead.
Which is the trustee, while retaining all the rights and privileges of property ownership, which is the beneficial interest.
How's that contrary to what you were saying?
The trustee acts only upon the beneficiary's direction. The property owner still retains all rights, such as the right to possession, to collect rent, mortgage, homestead exemption, and any other benefit he now has.
It's different than a
LLC, where an LLC would absorb all that in its entity, whereas if you had a land trust, you would absorb whatever entity actually owns the property. Like if our entity as a group in the Pinnacle Ventures LLC, it would retain all the rights of the deductions and collecting the rent and all that kind of stuff. And the people that had an interest in it, if we added Bob or John or whoever, they would not have those rights to collect rent. Just because I add you to my land trust on in Cerrito does not mean you have the right to go down there and collect my rent. Is that what
Does the
saying.
trustee? What does the trustee?
Unless you give them that right.
Have the right to do, or what does the trustee gain from this?
Is the trustee the actual trust, or a legal representative which manages the trust?
It is the person, I guess, that has legal title to the property.
The person.
They don't own the property, but they have legal title.
What's the difference
property.
between legal title and owning?
It says the trustee acts only on the beneficiary's direction.
And that beneficiary could be.
It sounds to me like a foundation where you run a foundation and you manage it. The trustee would be the manager.
Yeah. The trustee.
And it could be the same way with an LLC. An LLC could have a manager that's not a member. Okay.
Yeah.
So I need to.
It passes title without like if there's a loan on it, passes title without the do and sell clause for one. That's an important thing. It also hides from the public record the sales price, any information down at the courthouse, anything that you own, whether it's in an LLC's name, whether it's in your personal name, it would be taken off. It'd be taken off.
So a trust won't.
The trusted
Does not have to record the sales price?
No, it does not. And also,
say if there isn't a sale that takes place, is what I would
Okay,
understand.
that transfer may not record the price, but I'm assuming what we're saying is an individual or an LLC or some entity would have to purchase and then transfer ownership into the trust. And there would be a record of the sale.
I'm not certain on that. I don't know if they take that off or not. I'm not sure if it's removed or not, because what would be the point unless the actual land trust actually purchased the property? Then there would always be a record of it.
I guess
unless the
I can't imagine that
interested.
there's not.
And usually a land
For
trust,
taxation purposes, there has to be a record of the...
well, yes, there's a record, but not a public record. The land trust, there's a record of it somewhere, but it's not a public record.
It doesn't trigger a tax event to transfer property within a trust. I would say
Because of the St. Germain Act, I'm not sure if it included
Maybe
the
it's-
tax.
if you sell a piece of property where there's a change of hands of money, that would be a tax event, something that would be recorded and duly recorded at the courthouse. How much money was changed hands? But say if you have a piece of property that you want to, say you want to go into business with somebody else, and what you want to bring to the table is this piece of property that you have, and you want to you have somebody else that wants to go into business with you, and you want to give them part of this property, or you want to have the business, part of the assets you're bringing to the business as a whole is this property. Mm-hmm. So what you would do, rather than say, okay, well, the property's worth $100,000, let's go down to the courthouse, you bring $50,000, let's go down to the courthouse, we'll put your name on the deed along with my name on the deed, you give me $50,000, and we pay the tax on $50,000, and then your name is recorded on the deed, and then we're both definitely we're both in there. That's a sale. Now, another way, what I envision, another way to get to bring that in and to be able to leverage that asset between the two of you or whatever with another member is if you put it in a trust.
You could transfer.
And then you bring that new member into the trust, and he has equal membership in the trust. That's not a sale.
Okay, well, let me ask you
his
this.
name is on it as well, or that other person.
What are the implications, for example, of creating a trust? Let's say the four of us make a trust, and we transfer 100% of our holdings into it. And then we each have a 25% stake in the trust. I don't know that it works exactly that way. Probably not the same terminology.
It's not. I think it's whatever the trustee says it is. So if that the person, like you, would have a lot of power in that kind of situation. Where in an LLC, it's
you could have shares in the trust.
In an LLC, you have kind of like in a land trust, it's kind of like an absolute power. Like you can say whatever. You can say you only have whatever you say they get is what they get. They do have something. They do have a say, and you can hold up in court forever saying, well, I want this, I want that, but you have more absolute power. Where in an LLC, it's in the articles of the corporation it's set in writing that you have 25%, I have 25%, you have 25%, or whatever.
So that
in a land trust, it's a little more fuzzy, and the person who's a trustee or the person who's created it has more absolute power, has more authority.
Okay, what about
it depends on it goes along with the proportions of what each person transfers into the trust. Is that what you're saying?
Doesn't sound like it.
Not really. It's pretty much whatever you write up. I mean, it's not. It's pretty
Well, it
much.
sounds to me like that doesn't matter. You're basically saying that the trustee can change the beneficiary amount.
They can. From what I understand, the trustee can. It's pretty much. It's an absolute power. Where in LLC, it's not. Like if Bob was head of the land trust, he could say whatever our shit. He can say whatever. He can give us whatever.
There's got to be some kind of protection, because what about the bank?
That's LLC gives you the protection.
What about the bank?
I don't know. That's something that I really don't know that level of detail. But I know that
Because the bank has to have their protection.
In a land trust situation, you have more absolute powers than you do in an LLC. Now there are, like if you make an LLC such as PV or something, beneficiary, then there's a little bit more, there's more complexity in there. But the banks don't like that. The banks don't like it, but it's because of the St. Germain Act, or whatever the act is of 1982, that they have to do it. I'm not saying they like it, but they have to do it.
But there's got to be protection for the bank, and they have to have.
They're a lien holder. They're a lien holder, and if one of the trustees or if one of the beneficiaries would get sued, or they're not, that doesn't automatically mean that they're going to come after that portion of the ownership. It's not as cut. It's just another. It's more red tape, and that's the whole. We're talking about asset protection today, and that's what you want to do. You want to tie things up in so much red tape that it would take an attorney a lot of time and a lot of money to untangle it. And that's what you're doing. You're making a lot of red tape, a lot of hassle for someone to come after you. If you have, like you read from the Wikipedia article, if you have a lot of real estate holdings, if you have business interests, you have a lot of assets that someone could come after. You want to create as much red tape as you possibly can in order for them, so they just can't come and get it. And a land trust in conjunction with an LLC will provide that red tape. It's not perfect, nothing is perfect, but it does provide the red tape that's necessary to protect your assets. What are you guys looking up?
I was looking at Bigger Pockets. They have an article on land trust and the asset protection. Their take on a land trust, it says, in a nutshell, a land trust is a grantor trust. A grantor trust is a contract between three parties: the grantor, which is the creator of the trust, the trustee, who holds legal title to the property through the trust and typically controls the trust assets, and the beneficiary, who holds the use and enjoyment of the assets within the trust. The most common form of grantor trusts in our country is revocable living trusts. The great thing about grantor trusts is that separate tax filings are not required, since the profits, depreciation, and expenses associated with the asset will report on your personal 1040 return. Often investors are told they cannot form a land trust in a given state because there are no land trust statutes in that state. This information is not wholly correct. Even though only a handful of states have formal land trust statutes, every state has statutes regarding grantor trusts, and thus the land trust would be recognized as a viable entity in that state, since it is a grantor trust. I don't know if that was helpful or not.
That didn't help me yet. To be honest, that didn't help
So
me at all.
what's your primary? You have
It sounds really good. I don't want to just drink the Kool-Aid. I want to know what's in it.
It's a legal entity. It's not some crazy notion that somebody just thought up.
Well, I understand that.
Yeah.
But it's just you guys. You just act like you're just so surprised at all concepts, and we.
No, I'm not surprised about the whole concept. It's just a.
For example,
but some of the things that you said are different than my understanding. For example, you mentioned that the trustee has the right to choose the amount of the beneficiary, and that doesn't sound. But what that doesn't.
I'm not sure about all those aspects of it.
Well, that's a gigantic.
It is.
That's
a
fundamental.
I don't know how they divvy that out. I don't know. I know that the trustee and the grantor has more power than someone in an LLC would have.
Well, here's my concern.
Power. I do know that.
Well, here's where I come in, and I say this. This is, and maybe this is unfounded, but I'm thinking about adding, I'm thinking about adding people to the to a trust. Let's say you built a trust, and then you and I transferred our holdings into a trust, and then we wanted to add John and Donnie to the trust. Maybe they purchase into the trust. You know, they want to pay an amount to co-own something, and then they're going to have to be protected.
We're protected just by the virtue that they're recorded. I mean, in the trust, because they own the trust, and we couldn't sell the property until we couldn't do anything with the property until they were dealt with. So they could hold it up and you know, they could hold it up legally forever.
Well, that sounds like a very big.
I mean, you just don't go put anybody on that. You have to put someone that you trust or someone that you have that's giving you money or someone. You just don't go putting people on there. Of course you don't, because they actually hold legal title to the property. The
trustee is the one that owns the legal title to the property.
If we put their names on a land
as
trust
a beneficiary,
they can tie it up in the legal system for a long time. You just can't dissolve it, and the beneficiaries. I don't think you can they just doesn't disappear. You have to deal with them some way, either by buying them out or whatever. Or you can make them. I don't know how many trustees you can have. It depends on if they're a trustee or a beneficiary. That's something that we'd have to look more into. I don't know the answers to those questions. I do know that a land trust is a very good tool for asset protection, and to, you know, like if John and Donnie wanted something from us, or they, you know, it's a good business tool to use, and you can use several different ways. But it's different than an LLC. It's a lot different than an LLC. Especially as far as the banks are concerned.
This is, here's a little thing. I need to cite that I'm looking at a website called Bigger Pockets. It's a blog, I guess, Bigger Pockets blog, that kind of gives me a flavor of how LLC and land trusts
differ.
Yeah.
Oh, good.
Okay, this guy, he says, in my practice, the land trust is used as a title holding vehicle to minimize the risk of acceleration. This is the due on clock.
Mm-hmm.
The risk of acceleration when real estate is transferred into an LLC for asset protection, and there is no change in beneficial ownership. As many of you know, U.S. Code Title 12, Chapter 13, Section 1701J-3 limits a lender from accelerating a note when there is a transfer to an inter vivos trust in which the borrower is and remains a beneficiary. A real estate investor who desires the asset protection benefits of the LLC is often faced with this dilemma. Transfer the property into the LLC and risk the lender accelerating the note,
mm-hmm.
or keep the property in his own name and risk being liable.
Mm-hmm.
Hence, the land trust provides the remedy.
Right.
To solve the dilemma, an investor can establish a land trust to hold legal title to the property, wherein the investor is the trust beneficiary with rights of assignment. That rights of assignment sound like what you were talking about. After title is recorded in the name of the trust, the investor/beneficiary quietly assigns his beneficial interest to his LLC. The transfer goes unnoticed by the lender because it is not recorded. Once the interest is held by the LLC, as the trust beneficiary, becomes liable for the trust's debts and obligations. Similarly, the charging order protections will shield the land trust interest, i.e., personal property, from the individual's personal creditors. So you get the charging order protection from the LLC.
Right.
And you get the transfer. You get the transfer benefits
Of the
with the
beneficiary.
trust. Yeah.
But there have been, I've noticed, I mean, they do contact you. I don't know if you have to, but they are, according to that, they're not contacting the bank. But I've seen where you contact the bank where you tell them that it's being transferred into a
It's being-
trust.
I guess that way
I guess you
you're.
wouldn't really have to.
Here's the part that this is my big
changing your-
question that I don't understand. I mean, I can make a bunch of assumptions, but here's the part that I don't understand. We've got this asset that we transfer to a trust, and then we go to the bank, and I think when you say, okay, what are your assets, what's your income, that kind of thing, I think what you would have to say is, you can't say I own this building. I think you would have to say I'm the beneficiary of this. I'm a X percentage or
No,
X amount.
You're the grantor and the trustee. You do own the building. You do own the building. You own the land trust. You do own
If you're the trustee, but if you're not the trustee,
like if it was.
I'm assuming there can only be one trustee.
I'm assuming too.
I'm
not
assuming
sure.
that.
Yeah.
I don't know that. We've got a lot of questions that we need to ask.
We need to write these down.
Go ahead. That sounds good.
I'm trying.
So, if I'm the trustee, I own it. I have title. That's what we're reading? Is that correct? That may not be the right. There may be a difference between holding title and ownership.
That's right. That's right.
I don't
That's where
really
the trust
understand the
comes
difference.
in. That's where the trust comes in. Is that you don't own it. You hold
The
title
trust
to it.
owns it.
Well, the grantor owns it.
Is this a revocable trust?
I don't know.
I can understand that. That's something I can understand. If I'm mentally unfit, or I'm worried that I'm going to be mentally or physically unfit and able to do business, I can revocably grant someone permission to do business on my behalf, and he can sign the same as I can. He can make all the legal decisions and judgments. But then I have the ability to revoke that trust, and then that trust no longer exists. Therefore, I've technically always been the holder of the property, even though he could control it. That would be like a title holder. That's the difference between an owner and a title holder, I'm assuming. And I don't.
Yeah, I think you probably can make it just like anything else, revocable or irrevocable. I'm sure. I mean, I don't know. Couldn't you? Why wouldn't you be able to?
Well, I would think that it's either one or the other legally.
Yeah.
And based on the fact that you're transferring title,
And
I
that's
don't know.
one of the differences between a land trust and an LLC. If in an LLC it's irrevocable, you just can't revoke my right. You can't just kick me out and say you're done with. In a land trust, maybe you can. I don't know.
There's got to be more protection in that.
There has to be.
There has to be. Nobody would ever use
No one
it.
would ever do
It
it.
would be. You would never do it except a single owner, and that's not. There's got to be some protection there.
Well, I guess if you made, there's a difference between the trustee and the beneficiary, which in turn, I guess you would have to decide whether there could be more than one trustee. If a trustee, I don't think you can do that with. The beneficiary, maybe you can.
Well, but I'm saying there's got to be and can a trustee on most foundations? Let's look at the trustee of a church.
Mm-hmm.
The trustees of a church can be changed at any time.
Right. But is that usually a legal structure? Is that you're talking about legal?
Absolutely, it's legal.
I know
It's
they
required
have
order.
legal structures in churches, but
No, it's a legal.
I'm not sure if you using trustee as like a deacon or trustee in the legal sense.
Trustee in the
Just
legal
making
sense. No, we're talking about law here, so that's the reason I'm talking about legal. So because a person could And there's all kinds of reasons that has to be the case. People die. If a trustee were to die, there has to be a provision.
So what are some of the questions that we want to ask? Like when we have an expert that we can ask. What are some of the questions that we're not sure about?
How are the beneficiaries protected? What rights does the trustee have? And what does the trustee do? They have to have some. When you have responsibilities, you have to have rights.
Can there be more than one trustee? Which I don't think there can be. But
I don't know. There could be a board. What are the complications that could arise in dissolution? You know, if you pretty much in our LLC we made specific guidelines. Should one or more of mutual consent, should somebody want to dissolve the LLC, there is a
I think that's where the beneficiary comes in. There's no dissolving included. It's like it's like you being a beneficiary of a life insurance policy. You're just either you're on it or you're not. You get it or you don't. And the only way you get it is if something happens to the grantor or the trustee, or if it's then you're the beneficiary of that. Then it does that. I think that the main power is in the grantor and the trustee, not the beneficiary. Is what I'm thinking.
well, I think that has to do with whether it's as far as the grantor. I would think in order to lose the liability,
Incoming transmission.
I would think you would have to lose the ability to revoke it.
So can a land trust be irrevocable?
Or are they, by their very nature? I mean, it would make sense to me that it may be by its nature.
So, we're talking today about land trust and LLCs and how they differ as far as asset protection go.
Yeah, we've been kind of exploring. We're certainly not experts on these things, but we're kind of exploring exploring this tool of a land trust and why people use these land trusts. I think we've identified that there's a value to having a land trust when it comes to transferring properties, but we don't have a good understanding of what the rights and responsibilities of the trustee and the grantor are
Right.
in a land trust. But I guess we can. What I do have is a good understanding that that property can be transferred with a land trust and it not be recorded as a sale, which is valuable when it comes to mortgages with due on sale clauses and with tax avoiding a taxable event, a sale, a property sale that's recorded at the courthouse. Those are.
And that's another question about the that I have that you may have mentioned while I stepped out for a moment. Do you have? You mentioned the protection from knowing. I think what we're saying is the transfer from an individual or a corporation to a trust is not a recordable event for quantitative for
It's
dollar
not a-
purchases.
It's not a money. It's not a.
It's not a sale.
It's not a sale. Money doesn't change hands,
Okay.
and therefore.
So
it's
I'm
not a
assuming
taxable
that-
event.
I'm assuming that if you were going to use a trust in this manner and you were going to acquire more property, I'm assuming that if the trust purchases something, and I'm assuming that it has the ability, if the trust purchases property,
I'm not sure that. Go ahead.
Does the trust purchase?
I'm not sure if it does. I think the entity, the person or the LLC or the corporation, such as PV or whatever other corporation we have, would actually purchase it, or one of our individual names would purchase it and then move it into the land trust.
That
Yeah,
makes
I don't
sense
think
to
you're-
me.
I don't think it
I
actually
think maybe
purchases
this is one of
property.
a trust isn't like a person.
It's not a trust is not an entity, is what I'm thinking. I mean, I'm not
A trust is-
true on that. An LLC is an entity. An LLC, a corporation, acts the same as a person. A trust is not an entity, so being that
Well,
it's not an
LLC can-
entity,
An LLC can play a role in a trust
Right.
relationship.
Okay, and that makes
but
sense.
being that it's
That
not
makes
an
total
entity,
sense to
it
me.
can't purchase
but
property or do
I would
anything
think
like
that the amount of the purchase would be in the amount of the purchase would be in the
would be in the what?
would still be recordable by whom, whichever entity purchases, makes a purchase, and then it would be transferred to the trust.
Right. So I don't know why that is. I don't know
I think
if they,
it would
I don't
not
know if
be
they
the-
I don't know if they remove it. I think
I
it's
don't
just.
think-
I think it's just a matter.
I
of,
think that just the transfer is what's not recorded. The purchase has to be recorded. I would be very surprised if this is not the case. The purchase must be recorded. The transfer, because it's not a taxable event, that part would not be. So that you would not know.
Who cares?
You would not know that this trust, in effect, you would not know that you paid $50,000. Whoever purchased it, there would be that record of $50,000, and then the transfer to the ownership that would not have a record. But I can't. I know that they don't
It's not a
remove
transfer.
I just
records.
want to make
ownership
sure you
issue.
don't. You want to make sure you purchase in an LLC. Like you don't want someone going to the courthouse and saying, "Well, Donnie Somerville purchased 200 properties the past couple of years." If he's done it under a few LLCs or a few corporations and then transferred it into a land trust, it would be very difficult for someone to find that out. But yeah, it's not recorded into a land trust. I guess there's no record of it. And if someone asks you can't tell them unless they have a court order. I mean, it's a privacy issue just as much as it is anything else. But I don't know if, I mean, still, I guess you could still get to the, I mean, I don't know if they strike it. I mean, if this is
There's no, I can almost 100% guarantee there's no removing of the sale record with the taxation amount. That's not what would be. And they don't remove
You're still
those
owner.
records.
You're still the owner.
Well, you still
Even
purchased it. You purchased. Whoever purchases a piece of property,
Is
there's
the
going to be a record of that transaction taking place. There may not be a record of transferring the ownership. I don't know how that would work. There probably is a record of the transfer of ownership. There's just not an amount associated with it. And that's what I can see that as a possibility.
Most importantly, besides that, I mean, they can know whatever they want to know. They could find out one way or the other. But most importantly, it's a tool. Any judgments or liens against the entity, whether it's against your LLC or against you, are not against the land trust. So if you have 500 properties in your land trust, one of them gets sued, or you get sued personally, they can't go after the land trust.
It sounds like it is, unless you put it, the protection of the charge order. The charge order protection comes from the LLC that has the vested interest in the trust.
Is that what it said?
I think so. I think the charge order.
So you have to
Comes from
have
the
an LLC as a beneficiary.
Well,
so the beneficiary
that-
does
all
have
I'm
power.
going, I don't have it. All my experience is
Yeah.
what he read just a minute ago.
I mean, I'm just not sure.
think
I'm not
that
sure.
The LLC is what gives you the limited liability.
I'm not sure about that.
It sounds like it's
It's a
more
way
for.
to-
I'm not sure that an LLC. Then what would even be the point of why just not put it? I could see the one
Obfuscation.
point.
That's what it sounds like. The purpose of this is it's done, and the ability to. One thing you get is the ability to go from a single owner to multiple owners.
Yeah. What I can do is, I have a property worth $100,000, and I want to go in business with you, and you
Or leave it to an heir.
Yeah, and you've got $50,000, and rather than me rather than me selling you half of it and you giving me $50,000, and we record that you own half and I own half, we can, you can have it, we can put together an LLC.
Right.
You can put the $50,000 cash in the LLC. That's your contribution to the LLC. I can put together a trust with the LLC as a beneficiary
Right.
of that trust, or a trustee.
Trustee.
The LLC could be a trustee in a trust with the property that I own. And I could be a trustee. I need to be a trustee too, because of this Garn Saint Germain Act. I need to be a trustee in the trust
otherwise that
too,
won't work.
or it won't work. And then the LLC.
But it sounded to me like
As a
the
member-
LLC was the beneficiary, not the trustee.
I don't see why anybody. It could be any.
Well-
LLC is an entity. It's a person, so it can be a
It
trustee.
can be that
I'm not saying that it can't
I'm
be.
the grantor. Well, I guess there's the.
It could even be the grantor, even.
I think there are these three parts, but they're not.
We don't fully understand.
We don't fully understand, but the LLC. Where I was going with this is okay. So you have $50,000. I have $100,000 property. We want to go into business together. We both. So you could give me $50,000 and I could put your name on the property, and then we would both have $50,000 worth of property. But there's a tax event there,
and the possibility that there's a mortgage on it and they wouldn't allow it.
they wouldn't
Deal and
allow
sale
it.
clause.
That and both our names are on the property. If somebody wants to sue us, they could go down there and find out who we were and what we owned. Those are things that we don't want to have happen. So what we do is we go and we put together an LLC, and I'm a member of the LLC and you're a member of the LLC. And what you're going to bring to the LLC is $50,000 cash. So you bring that in, that's your contribution to the LLC. My contribution to the LLC is this property. But I don't want to just sell the property to the LLC. That's a tax event. So what I do is I make a trust where I'm the grantor of the trust. I still own the property, but I am granting the title of the property and the ability to go and get liens on the property, legal title to the property. If you have legal title to a property, you can go to a bank and say, here's my title to this property. I can get a lien. This is it.
Exactly.
So I grant you title. I grant title to the LLC, but I still own the property, and I am still owner. So there has been
Actually,
no
you grant
sale.
title to the land trust, right? That the LLC is the trustee on, right?
I'm title to the land.
You grant
Granting title. Well,
You don't grant title to
we're forming a land trust,
right.
and I am granting the land trust.
The title
the
actually
land
be-
trust.
The trustee of the land trust is the LLC, is what he said.
Right,
the
but
trustee-
the LLC won't hold title. The land trust will hold title, won't it?
Well, the land
The
trust.
trustee is the person that holds title.
The land trust
Okay.
is what this relationship is called.
Mhm.
It's sort of like a marriage,
Right.
where I'm in
not
the
an
marriage
entity.
and he's in the marriage. But there's a bride and there's a groom, and what our relationship is called is a marriage. But the marriage doesn't own.
Right.
It's sort of like so we make a land trust,
Mhm.
which is the marriage, but the LLC, I give the LLC, he puts $50,000, that's his contribution to the LLC. My contribution is,
The
I
property.
grant title. I don't put the property on there. I own the property, but I grant title to the LLC, and that is the birth of a land trust.
Okay, in
The-
that
the
case, there
LLC
it has to be irrevocable.
Yeah, it has to be irrevocable.
That's not necessary. I don't
I don't
agree
know.
with that. That's
It
not
seems-
true. There's
it
If
people.
it
seems
weren't,
like they
you
could
could
come
just
back.
revoke it immediately.
They could say, well, you did that, but I mean, it seems to me like you to have the liability protection, you would want it to be irrevocable. So, like, somebody couldn't come back and say,
You
"Well,
revoke this.
snatch that right back out of there."
Yeah,
You
I
know
think
me,
that's
you
true.
know.
You might have to, say that from the beginning. But here's a post on Crew Online. They're talking about banks and the due on sale clause and that kind of thing, to give you the gist of it. But he's saying a trust can assume liability for a loan that is assumable. You can transfer property into a trust for your own benefit, even if there is a non-assumable loan per the Garn-St. Germain Act. However, the original borrower is still liable for the promissory note. The land trust, as a revocable living trust, does not need a federal ID number, since the mortgage interest is still deductible to the grantor beneficiary. So the beneficiary might hold more clout than we think, as per the grantor provisions of the IRC section 671 and 678. So he's saying that this is revocable. That can be revocable. So maybe you have to say that from the very beginning. You have to let that be known from the very beginning, like when you do a bank account, either it's revocable or irrevocable. I don't know. I just don't know.
I'd like for you to reread that so I can get a second pass at it.
Let me read the whole thing first, because this is a person that was basically trying to, he's telling the bank that he's putting his property into a land trust. And then again, this is on Crew Online. This is not any of what we got. This is the question. Mr. Bronchick, and he's an attorney, I think, you say that the trust can assume responsibility for the loans. So far, it's been my experience that this is false. Example: before I knew about a land trust, I bought a house which is financed through Norwest. We signed our names and social security numbers at closing 3 years ago. Just recently, I learned about trust and placed my property into a land trust. I contacted Norwest and told them that this was done per the Garn-St. Germain Depository Institutions Act, and said that I'd like the trust placed on the loan and have the interest reported under the trust EIN. So that's making me think that the trust is an entity, which would be contrary to what you guys are saying.
No, you're the one that said that it was not an entity.
That's what I'm saying. I think it's not.
What I was thinking.
I'm thinking it's not, but what you read,
These
I
are
don't
two
know.
people arguing about
This is the two people arguing. I don't know. I mean, I don't think it is. I'm like you, think it's a marriage, but it's contrary to what we're saying, I should say.
Yeah.
Not
So
you.
now he's saying his trust has an EIN, which I wouldn't think that a trust would have an EIN.
Right.
I
Well,
would
this
think
is-
an LLC.
This is, well,
or
he's
whatever.
not. He's not.
Yeah,
I don't.
okay.
I think this is what the problem is. It's
Yeah.
not. He's trying to do this, and it's not. He's incorrect.
He has made a trust be
An
something
entity,
that it's not.
something that's not. So this is
Something
what
that
we're.
should- okay,
I'm
so
just
Coming
trying
up
let's
next,
get-
we're going to diagnose people used based on Google. We're going to do medical.
No, we're just trying to
diagnosis.
dissect. We're trying to dissect what other people have done.
Yeah.
What
I
other
think
people are trying to
both
do
of us-
and dissect it and understand it.
I
So
think
this is-
that this guy, this is what I think is the writer of this letter,
Uh-huh.
and getting an EIN. He thought he was getting an EIN for a land trust, but he was getting an EIN for something else.
Right,
Let's
because
see,
This guy is going to say this land trust, that land trusts don't have EINs.
Right,
Go
right,
ahead.
right.
That's my prediction.
And he's going to a bank. You know, he's letting them know that that's kind of like you would with an LLC or something. So, keeping in mind that we believe that that a land trust is not an entity, right? Okay.
Yeah.
So I contacted Norwest. I'm going to read this over again. I contacted Norwest and I told them that this was done per the Garn-St. Germain Depository Institutions Act, and that I'd like the trust placed on the loan and have the interest reported under the trust EIN. They refused. Wait, it gets better. I didn't make a big stink about it because I was going to refinance to lock in the lower rate. So I figured I'd try my luck on a different institution, BB&T. Everything was going smoothly. I sent the lender a copy of the trust agreement as they requested. They reviewed it, said no problem, The trust is fine, and the EIN will be on the note, etc., etc. That's strange, okay. Then right at the closing table, bam, the phone rings and it's BB&T. Someone decided it was now not all right. Here, Bob.
Yeah.
Are you listening?
Uh-huh.
Someone decided it was not all right, and if I wanted to close, I need to quit claim it out of the trust, close, and quit claim it back into the trust. Now I'm back to square one because I don't want to file interest under the trust EIN. I can't win. What's going on? Who's right? Mr. Bronchick or the mortgage companies? Or am I missing something important? And the mortgage companies see my ignorance and are taking advantage. I haven't been able to shed light on it. Can you all help?
I don't think they're taking advantage. I think he missed the boat.
And this is what
I think that he's getting confused what an LLC and a trust is.
This is interesting to see what he says. I think you misconstrued what I said. A trust can assume liability for a loan that is assumable, pre-1989 FHA loan. You can transfer property into a trust for your own benefit, even if there is a non-assumable loan per the Garn-St. Germain Act. However, the original borrower is still liable for the promissory note, so whether it's an LLC or a person. The land trust, as a revocable living trust, does not need a federal ID number, which we agree on, since the mortgage interest is still deductible to the grantor beneficiary as per the grantor provisions of IRC Section 671 and 678. Again, whether it's an LLC or a person. Most conventional lenders require that the property be in your name for funding for a purchase, money, loan, or refinance. Thus, it is not surprising that BB&T insisted that you quit claim it out of the trust for the refinance. There's nothing legally wrong with having it in a trust for a refi, but most lenders are just plain ignorant.
Well, and that makes sense. That goes along with what I'm reading here.
The non-conventional lenders I deal with let me buy and refi in a trust, having the trustee sign the note and mortgage on behalf of the trust, and me co-sign the promissory note. A non-conventional lender, like if we wanted to borrow money from you, or if you wanted to have an interest in it, and we put you on the note, or we do a land, kind of like what we were talking about before. After the refi, you can simply quit claim it back to the trust, and that's a whole nother section about quit claim. I want to talk about quit claims at some point. Quit claims and how it relates to land trust and how it relates to the whole asset protection and how you can use it as a tool. But that's we've already been on an hour, so that's a whole nother section. But in the future, I recommend just transferring the property to the trust and say nothing. If the lender contacts you, most don't, then give them a copy of the trust.
Okay, so what concerns me there is what one of my early questions were about what this is said. It sounds to me like this grantor trusts are not, they're not designed for multiple non-familial, or they're not designed for business, is what it sounds like. I may be totally wrong.
I would disagree, because he just got through saying that when they borrow money against it. I mean,
one of the things it's talking about an EIN, whether you need one or not, is that you don't need an employee EIN if it's a grantor trust, a technical term that basically means a trust is either revocable or provides benefits for the person who established the trust. Banks will not open accounts in the name of a trust without a tax number, and that sounds like exactly what we're saying. The bank's not going to do business with you without an EIN, and an EIN is not appropriate for this kind of. It sounds to me like it's after you've developed your.
A trust doesn't hold an asset. A trust describes how an asset is
related.
How it's related.
Like a marriage,
who the beneficiary is, and
yeah,
and I can believe that. That makes perfect sense. So my concern is that when you put it into the trust, perhaps I'm not saying this is true. What is without transferring it back out of the trust, without quit claiming it, can you use it to borrow additional monies on that? Is there
limitations on
yeah,
what you
because
can do
it's
with it?
because
I'm going to write that question down.
meaning can you HELOC with it? Can you once it's in that, because the banks are not going. It sounds to me like here's two different sources saying that banks don't do business like that with these with the grantor trust. They won't do that. They won't do business with that as the
Unless you do what he said and quit claim it in and out. Like we just do. If it's in the land trust and we want to refinance it, we quit claim it out of it.
What are the implications of
refinance
that?
it and then go back to the bank and say, hey, I want to do this. I don't know.
That sounds like a lot of manipulation.
Well, that's the name of the game. I mean, that's.
And it may be perfectly fine.
But the
it may
bank
be
still
normal.
has their lien on it. They don't lose their position on the mortgage. Has nothing to do with that. They're not going to. You bankrupt it, and they're still going to get their money. I mean, if you they're still going to
sound like they like doing
They're
that.
still going to come after you. They don't like doing it, but it's the act.
So we need to find that information out before we can determine.
But you don't tell them, is what I'm saying. You don't go there and say, like this guy did. You don't go and say,
Oh, I agree.
I'm going to do this. I want my EIN number and blah 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 blah. You don't do it. If it's already in a land trust, you quit claim it out. So then the bank sees that you have the LLC, or if you're borrowing money in your personal name or the LLC, they see that you hold title to it. And then once the transaction is complete, then you go back and.
Well, I will say
put it in
some
the land
banks
trust
won't
again.
do loans unless you've held title something a certain amount of time.
But it's
We
not
experienced
recorded.
that with-
It's not a land
Yeah,
trust.
it is.
It's
A
not
quit claim is a
A
deed.
quit claim is recorded, yes. A
Yeah.
quit claim is
So if you were
recorded.
going to, if you had it in a trust name and you said, okay, I'm going to borrow money, I'm going to quit claim it back over to myself,
right. They
or
must-
to the LLC or whatever entity is going to be responsible for that. That's a deed. A quit claim is a deed, and therefore
I understand
it's a
that.
transfer.
I understand
and
it's
so,
a deed.
So
what are you saying? The bank
I'm
will
saying,
not allow
for
it?
example, they wanted us to own something for a minimum of 6 months before they would loan money on it. The particular instance that we had with
Well, that's
This
not that-
quit claim thing, when they did that quit claim, that was a taxable event right there. That I don't understand.
I would
that just
defeats the
that
benefit.
defeats the whole reason for the trust thing. I that's what I thought when I read that, and it's like they had him do the quit claim. It's like, well, the trust didn't do him any good.
Well, and if you did it into an LLC, you still got that same issue. Whether you transfer it to individuals, an individual, multiple individuals, or a legal entity such as an
because
LLC.
he was doing it wrong.
Well,
he was doing it wrong.
but it sounds like
If you quit claim it to a land trust, though, there's not a tax event because the land trust
Right.
isn't a person.
okay, and
So
I
it would be
can
a-
understand
It would be
that.
a tax event only to
The other direction.
The other direction.
But what I'm saying, in order to borrow money, it would be. Is that? I'm not saying it is. I'm saying that's what it
I mean,
sounds
if the LLC is the grantor, and then you're transferring it into a land trust, which is not an entity, it's basically a marriage between the grantor and whoever else they want to have on it, which would be the trust. I don't know if the trustee and the grantor could be the same person. I don't know, but it wouldn't be a tax event because you're doing it. You're doing it to yourself. It'd be like giving money to yourself. So would that be a tax event? Am I seeing that correctly? Like if I transfer money, if I'm doing it in a land trust, if I'm LQA and I'm I'm doing a quitclaim deed to into a land trust, which is not an entity, and then I quitclaim it out. Is that a tax event? Because I'm giving it back to myself, giving it back to the entity, which is LQA. I don't know.
I would think it would be. I would think transferring title to an LLC, a person or persons, would be the same as me
I'm
selling.
saying an LLC that actually owns the note, has the note, that's getting the mortgage, and then it's quit claiming it to the land trust, which with the LLC as the trustee and the grantor, and then transferring it back. That's the same entity. I could see if it was a person, if it was you, Robert Dawson, transferring it into a land trust with LQA being the grantor, and then the grantor transferring it back to you, I could see how that could be a tax event. But if everything's the same, if it's the same entity that's doing the whole transaction, I don't see how it would be a tax event. I mean, I might be missing something. I don't know.
I don't know either, but I would think when you create a deed, I can't imagine that it's not. With the exception,
so if you're married, if you I'm trying to think of a circumstance where it would be similar on like a personal. I don't know. I mean, if you're giving money to yourself, if you go borrow your own money, if you're giving money to yourself,
that's not the same.
If you give money to yourself, that's not the taxable event.
A grantor trust is a legal entity an individual creates to hold and control his assets. A grantor trust is different from a grantor of a trust. A grantor trust is the legal entity a person creates, whereas the grantor of a trust is the person who creates it. The person who creates a trust is always called the grantor, regardless of whether he creates a grantor trust or a different kind. In a grantor trust, the grantor creates a trust and transfers assets to it. This type of trust is typically revocable. As long as the grantor is alive, he can make changes to the terms of the trust or even revoke it altogether.
Exactly, that's what I was saying.
I think that
makes
would
it
be a trust. That would be like that trust would be the mission of that trust would be maybe to maintenance purposes for
Upon the grantor's death, however, the trust becomes irrevocable. This means that it must be administered according to the terms the grantor created while he was living. That's why, based on what I'm reading here, it doesn't sound like it's the appropriate tool for an individual to grant. It probably is for an LLC. An LLC could probably still do it, and still, because the LLC, if the LLC is the grantor, this is hypothetical, I don't even know if you can do this. I think you can, but if an LLC, if we take our LLC and we transfer it to a trust, and then for whatever reason, an individual, like your scenario where you want to bring somebody in without involving them. The only reason I would think you want to do that is a spouse or life partner or something where you give 100% trust to them, because otherwise it sounds to me like you can take it away. You can take away that benefit. You, as the homeowner that transfers the asset in, could remove somebody as a beneficiary, and that goes along with what we've heard about people using trusts as methods of avoiding inheritance tax. Is they can go in at any time and say, okay, I'm leaving, you're my two sons, I'll leave it equally to you, and then I get mad at you and I say, okay, you're written off and now you're the sole beneficiary, and that sounds like the same kind of institution. So if an LLC transferred it, it sounds like it would be a good thing, because there's not an individual.
It's controlled by a group.
It's controlled by the group,
like
the responsibilities and the contract you have, the articles that you have, the articles that you have that rule how you do things still persist,
right,
because it is irrevocable. I think I've pretty much established that. That was my problem. There's got to be a protection for somebody. The only reason somebody would do this is if they were protected. The only way a person could be protected in this instance is to be the grantor. I don't think under any other circumstance, if you are not a grantor, because the whole purpose of this is for the benefit of the grantor. If you are not the grantor, you can't add people in. You can make them a beneficiary, but the problem is a beneficiary can be removed. It's like a life insurance
you can
or
also
anything
do
else.
A quit claim. That person has the option to do a quit claim too.
If you dissolve it, or you quit claim it, you're transferring it back out of that scenario, and then you got to transfer it back in if you're trying to do that. What I'm saying is, it's not made. It is. Sounds like it's very different from an LLC or a corporation in that regard. And the grantor has 100% of the power. And that's what it sounds like. So it would only be appropriate if your LLC was the grantor, not individuals.
Yeah, because the individuals, like you said,
Whoever is the
grants
grant.
it, one person's not. That's what I was saying initially. One person's not calling the shots. One person can't say, okay, you're out, you're in, you're out, you're in, you're out, you're in. And that's what I was saying initially. It gives one person too much control or power. Where if the LLC was the grantor, like the three of us, the four of us, then one person doesn't have all the control or the power. So, like, yeah, I agree with you. Unless we're proved otherwise, it's important for the LLC, if you're going to have that kind of arrangement, like as far as a business partner or whatever.
And this goes along exactly with what we've read about trusts before. While the grantor is living, he is usually responsible for the taxes on the trust's income. Typically, the beneficiaries receive the income, but do not have to pay any income taxes on it. And we've been told that before with other kinds of trusts, such as charitable remainder, as a way to give your children an income without giving them liability.
Now Donnie looks confused.
It's all really challenging, isn't it?
Well, it's new. It's new ground.
Yeah.
We've got a little bit of a basis that we've talked about this before.
Here.
It is, and it's learning, and
Yeah.
we're not going to be experts. And I just sign on the dotted line because we discussed it for an hour.
We touched on this, like our last meeting in January. Not that it was 2 years ago. It'll be 2 years ago. God, it's hard to believe. It'll be 2 years ago where we did the whole weekend extravaganza on asset protection.
Yes.
That's been 2 years ago now, almost. Anyway, we touched on it then and the different tools and all that kind of stuff, but we haven't visited it. I guess in at least 2 years. So it's been that long. So I just wanted to talk about it today and talk about how it could be a tool to be used for our advantage, if it could be. So you guys want to wrap it up?
Okay.
You have any other questions or comments, Bob or Donnie?
Well, it's been a very beneficial hour for me to bring this out, bring this to light about land trusts as a tool, getting a better appreciation of creative ways to move assets about we're gonna I sense that at some point in the future we're gonna use a land trust once we figure out what it's good for.
Next week we're going to talk about LLCs and the importance of LLCs as far as asset protection, which we know much more about as far as asset protection and how it relates to our business and why you should use an LLC to purchase property, businesses, and so on and so forth, and all the ins and outs of that. So we'll talk about that next week on December 5th at 1 o'clock, right? You're all going to be here? John will be here next week.
If you're planning on that.
Oh, I can't. We're scheduled to be out of town next week. We might have to do a recording or something. It might have to be the week after that. I forgot about that.
Okay.
Anyway, we'll talk about it next week.
Joining us here on landlordsjournal.com for our weekly podcast was originally aired on November 28, 2010. Be sure to join us on landlordsjournal.com and check out our schedule for a future podcast. And also be sure to check out our email list where you will receive a free ebook all about real estate investing for signing up to our email list. In addition, our forums are open. You can discuss our podcast there, and we be on the lookout for on our website for. We plan on having guest speakers and a call-in feature to our show, so be on the lookout for that. You will be able to call in and ask questions or comment on whether you are a tenant, real estate investor, or landlord. So, as always, you can find us over at northgeneral.com, and we'll see you next time. Take care.